Greetings and welcome to the United States District Court for the Middle District of Louisiana Black History Month celebration. 2021 marks the 25th year that the Louisiana Middle District Court and the United States Attorney's Office for the Middle District have celebrated Black History Month. Sadly, because of the pandemic, we cannot come together to celebrate this traditional event. Nevertheless, we wanted to find another way to celebrate this very important occasion, so we prepared a virtual celebration that we are pleased to share with you by video. First, the court will invite Mike Jefferson, Assistant United States Attorney and long-serving chairperson of the Middle District's Black History Month celebration, who will offer brief remarks on behalf of the United States Attorney's Office. Mr. Jefferson.
Greetings. In 1996, then U.S. Attorney L.J. Email tasked his first assistant, Brian A. Jackson, with putting together an African American history program for the United States Attorney's Office. First Assistant Jackson, now Judge Jackson, indeed put together a program which was so popular that then Chief Judge John V. Parker asked him to put together such a program annually on behalf of the entire courthouse family. Since that initial celebration, the judges of the Federal Middle District Courts of Louisiana, the United States Attorney's Office, and the entire courthouse family have come together annually to celebrate African American History Month. Although the annual celebration was adopted as a quote-unquote court function, it has enjoyed the full support of every U.S. attorney, from Mr. Email to our most recent U.S. attorney, Brandon Freeman. The program template put in place by First Assistant Jackson continues to serve the Planning Committee well. Each year, our celebrations have been educational, inspirational, motivational, entertaining, and uplifting. We've been favored with presentations by professionals from various walks of life, attorneys, judges, physicians. We've also had nationally renowned entertainers and elected officials, as well as other community and religious leaders. Admittedly, this year's celebration takes on a slightly different posture considering the effects of COVID-19. The challenges of the pandemic notwithstanding, we commend Chief Judge Skelly Dick for her recognition of and unwavering commitment to ensuring that this important celebration goes forward. While this year's program occurs under more technological than social conditions, we look forward to a great celebration today and in the coming year when the citizens of the Middle District and elsewhere will again be able to join us in person and celebrate in the more traditional fashion to which we and they have become accustomed. We also congratulate our fellow colleague and chair of this year's celebration, Assistant U.S. Attorney Jamie Flowers, who has put together an outstanding program for your enjoyment. Finally, we congratulate and thank the many persons who have shared their time and talents over the years to make every year's celebration the successes that they've been. We also thank those who, by their presence, shared with us in the annual celebrations. It is our sincere hope that celebrations such as these will assist us in truly becoming one nation, under God, indivisible, with liberty and justice for all. Please enjoy the celebration. Thank you.
Thank you, Mr. Jefferson, for those remarks. It is now my privilege to introduce to you our keynote speaker. It was Dr. Martin Luther King Jr. who said, "Everyone can be great because anybody can serve." Honorable Brian Jackson epitomizes that truth. Judge Jackson, our keynote speaker, was born in New Orleans, Louisiana in 1960 and his elementary school years coincided with the heart of the civil rights movement. Judge Jackson earned his undergraduate degree from Xavier University in New Orleans. In 1982, Judge Jackson moved to Baton Rouge to attend Southern University Law Center. Thereafter, he obtained advanced legal education and degree from Georgetown University. Judge Jackson's early career first took him away from his home. He practiced, or better to say, he served the Department of Justice for over 16 years. First, as an attorney in the Los Angeles office of what was at the time the United States Immigration and Naturalization Service. In 1987, Judge Jackson was promoted to Assistant General Counsel of INS and continued his service in Washington, D.C. In 1998, Judge Jackson returned to New Orleans, where he served as a Special Assistant United States Attorney and later as an Assistant United States Attorney for the Eastern District of Louisiana. While serving the United States Attorney's Office, Judge Jackson was recruited by then Deputy Attorney General Eric Holder to train new United States attorneys. After many years of public service, Judge Jackson went into private practice as a partner at the New Orleans law firm of Lisco and Lewis. In 2009, President Barack Obama nominated Judge Jackson to fill a vacancy for a district judge in the Middle District of Louisiana. The Senate confirmed Judge Jackson on June 15, 2010, in a 96-0 vote. Tragically, just over a year after Judge Jackson's confirmation, then Chief Judge Ralph Tyson, a great friend and mentor to Judge Jackson, passed away, and Judge Jackson was called upon to lead the Middle District as its Chief District Judge. In his 10 years serving the United States Middle District Court for the Middle District of Louisiana, Judge Jackson has not only provided sage leadership to our court, but he has served on the Circuit Judicial Council and many of its committees. He was appointed by Chief Justice Roberts to serve on the Judicial Resources Committee of the Judicial Conference of the United States of America. Just this month, Judge Jackson was asked to deliver a nationally broadcast keynote address for the Black History Month celebration of the administrative offices of the United States courts. It is with great pleasure that I introduce Honorable Brian A. Jackson to offer remarks in this 2021 Black History Month celebration for the Middle District of Louisiana. Judge Jackson.
Thank you, Chief Judge Dick. Thank you for your friendship, and thanks especially for your leadership of our court over the last few years. I am honored to serve as this year's speaker for the African American History Celebration here in the Middle District of Louisiana. As has been noted, this is our 26 years celebrating this wonderful event as we remember the important contributions of African Americans. And so it is indeed an important remembrance, not just for African Americans, but indeed for all Americans. Let's start off by discussing why we celebrate Black History Month. Well, as many of you know, we pause each February to remember and to commemorate the sacrifices and contributions of so many men and women of all races who are committed and who have been committed to the cause of justice and equity for all Americans, and especially African Americans throughout our nations. Most of their contributions have not been enshrined in the history books. Most of you know that Black History Month, as it has now been known for so many years, was first proposed in 1926 by the noted historian, Dr. Carter G. Woodson. Dr. Woodson was the son of enslaved parents. He was educated at the University of Chicago and became just the second African American to earn a PhD from Harvard University, the first being Dr. W.E.B. Du Bois, one of the founders of the NAACP. Believing that the numerous contributions and sacrifices made by African Americans to the growth and development of our nation was, at least at that time, largely ignored and overlooked, Dr. Woodson proposed that we pause 1 week each year in recognition of these important contributions. Now, one of the organizations that Dr. Woodson founded was an organization called the Association for the Study of African American Life and History, and it is still in existence today. This is the organization that each year proposes a theme for Black History Month and offers suggestions on ways to celebrate Black history. Now, Dr. Woodson proposed that we celebrate Black History Week each February, the second week of February, because that was the week that two very famous and influential Americans were born, Abraham Lincoln and Frederick Douglass. Now, in the 1970s, Black History Month was expanded to include, Black History Week was expanded to include the entire month. And in 1976, President Gerald Ford formally declared February to be Black History Month in the United States. And in doing so, he urged all Americans to, quote, seize the opportunity to honor the too often neglected accomplishments of Black Americans in every endeavor throughout our nation's history. And so that's what we're doing here today, pausing to seize this opportunity to remember, to commemorate, and to thank those who worked so hard and who revealed the courage to commit themselves to the fulfillment of the goal of our founding fathers to form a more perfect union. Now, this year's national theme is the Black family, representation, identity, and diversity. With apologies to the Association for the Study of African American Life and History, I beg your indulgence as I depart from this national theme and instead focus on what I believe to be a more appropriate observation for our purposes here today, and that is the role of the federal courts in protecting and promoting the rights of African Americans. Now, I admit that I'm not here to provide anything particularly profound or even scholarly. Very often in the past, when I've been asked to speak at Black History Month programs, I shared a lot about myself, about growing up in the Deep South during the Civil Rights era and my path to the bench. But today, I wish to simply remember some of the courageous men and women, some regular citizens, some judges, some lawyers, who so fearlessly defied convention, challenged the status quo, and who in many cases suffered greatly because of their devotion to the Constitution, but who inspired me and so many others in doing so. Unfortunately, time does not permit me to discuss all of the heroic fellow citizens and judges and lawyers who have contributed to the cause of justice and equity in our nation. I'll just try to mention a few. But after my remarks, I encourage you to learn more about these great Americans who fought so valiantly for the Constitution. Now, some of these brave citizens and lawyers and judges are well chronicled in the history books and in reported decisions, like Dred Scott, Rosa Parks, and my good friend Ruby Bridges, who at the age of just 6 years old helped to desegregate Louisiana schools. Many of you recall that we were blessed to have Ruby with us as one of our keynote speakers at a prior Black History Month celebration. But again, what I'd like to do today is just mention a few real American heroes, lawyers, litigants, and judges whose bravery and courage changed our nation. Now, Webster's dictionary describes a champion as not only one who defeats his competitors, but one who fights for or defends any person or cause. Today, we will discuss a few valiant people who, because of their contributions, served as champions for the cause of justice and equality, and who must never be forgotten. We all know that, sadly, the early years of our republic were not kind to persons of African descent. We know that the first enslaved Africans, at least according to the historians, were brought to our shores in 1619, and that enslaved persons were considered to be chattel, property within the laws of the United States. Early pre-Civil War efforts to seek judicial recognition of full citizenship rights to persons of African descent proved largely futile. Of course, the most famous of those cases was the case of Dred Scott versus Sanford. Mr. Scott, who along with his wife was enslaved, essentially sued for his freedom and that of his wife, arguing that because they lived in a territory where slavery was banned, they could no longer be considered to be enslaved. Ultimately, the case was accepted by the U.S. Supreme Court, and in a 7-2 decision, the court ruled in 1857 that persons of African descent, whether slave or free, living in the United States, were not United States citizens and could not bring suit in federal court and could not enjoy other fundamental rights of U.S. citizenship. Although we know of the unfortunate results of the case, the courage of Mr. Scott and that of his wife, Mrs. Harriet Robinson Scott, and the brave lawyers who represented them, many of whom did so on a pro bono basis, including Roswell Field, Montgomery Blair, George Curtis, and others, were champions in the cause of justice and equality, and they must never be forgotten. Thankfully, others, however, with a fierce determination to uphold this nation's ideals, pressed on. As Louisianians, we must think about and consider Attorney Louis A. Martinette. Mr. Martinet was among the very first African-American lawyers to practice in the state of Louisiana. He was born in St. Martinsville, Louisiana, and later moved to New Orleans. He was a fascinating man. Many would call him today to be consider him to be a Renaissance man in many respects. During the Reconstruction era, he served in the Louisiana legislature. He was an educator, a newspaper publisher, and even earned a medical degree. Eventually, he earned a law degree. He was very, very active in social and political affairs throughout the state of Louisiana, and he was, by all accounts, the brains and principal strategist behind the effort to prove that the U.S. Supreme Court in the Dred Scott case was wrong. I will not here offer a detailed recitation of the facts of the case. You can turn to the history books for that. But you will recall that Homer Adolph Plessy, part black, part white, a citizen of my hometown of New Orleans, a devout Catholic of French and Haitian heritage, a shoemaker, purchased a first-class ticket and attempted to be seated on a railroad car from New Orleans to Covington, Louisiana, in the whites-only section of the train. He was, of course, arrested for this unthinkable act and was later convicted under Louisiana's Separate Car Act, which mandated the separation of races in passenger rail cars. For many, many years leading up to Mr. Plessy's courageous act of defiance, it was Louis Martinet who championed the social, political, and financial forces all pledged to defy this inherently flawed legislative act. In what has been described by many to be one of the most shameful and regrettable decisions of the High Court, the justices upheld the rights of states to enact and enforce separate but equal laws in a variety of public contexts, including rail cars. The lone dissenter in the Plessy case was Justice John Marshall Harlan, a native of Kentucky. He was born into a family of great privilege, and in fact, at one point, his family owned slaves. He was named after the first Chief Justice of the United States, John Marshall of Virginia. He fought in the Union Army and eventually rose to the rank of colonel. But he was no fan of President Abraham Lincoln's Emancipation Proclamation. At one time, he called it unconstitutional, null, and void. However, his views on race evolved over time, and he became a fierce advocate for the recognition of constitutional rights of all Americans, including African Americans. In fact, when asked to explain his evolving views, he said, to paraphrase, "I'd rather be right than consistent." As the lone dissenter in the Plessy case, Justice Harlan famously wrote a beautiful and inspiring dissent in which he noted that, quote, "Our Constitution is colorblind." Sadly, Justice Harlan, as we know, was unable to convince his fellow justices that in the context of constitutional and civil rights, separate is inherently unequal. And so, despite the Plessy case, Mr. Martinet continued to explore ways to challenge segregation laws in the Deep South, and he inspired countless others of all races to challenge such laws throughout the United States. And by the way, when Homer Plessy was first approached in 1892 by the conductor one of the things he told the conductor was that I am an American citizen, a strong rebuke of the Dred Scott case, and a recognition of his rights under the 14th Amendment. My friends, Louis A. Martinet and Homer Adolph Plessy were champions for the cause of justice and equality, and they must never be forgotten. Now, in 1906, the federal courts took up yet another case involving the rights of citizens at this time of all races. And interestingly, it was yet another African-American citizen and African-American lawyers who brought the case that ultimately resulted in the recognition that the rights enshrined in our federal Constitution and the Bill of Rights extend to all defendants in all criminal proceedings in both state court and in federal court. Today, we take it for granted that persons who are accused of a crime are entitled to a fair trial with competent lawyers, by impartial jurors, and all the other protections afforded by the Constitution. But this was not always the case. The case was State of Tennessee versus Ed Johnson. It was truly one of the landmark cases in our nation's history. In January of 1906, Mr. Johnson was accused of raping a white woman in Chattanooga, Tennessee. He was 19 years old at the time. He had no criminal record whatsoever. And there was no witnesses to the crime, including by the victim herself. She testified that she could not actually see her assailant, but she thought she recognized Mr. Johnson's voice, and on that basis, he was convicted. Now, 3 days after the commission of the crime, Mr. Johnson was arrested, again, despite the absence of any other evidence. Mr. Johnson, who vigorously maintained his innocence until the time of his death, was placed on trial a mere 2 weeks after the crime was committed. Now, while lawyers were appointed to represent him, neither of those lawyers had any experience in criminal law. Of course, Mr. Johnson was thereafter convicted by a jury of all white men, and his lawyers, incredibly, convinced him to waive all of his appeal rights. The presiding judge immediately sentenced him to death to be carried out a mere 4 days after the verdict. But it was two black lawyers in Chattanooga who had the audacity to believe that they could turn to the federal courts for constitutional relief, which had never been done before, of course. Eventually, Noah Pardon and Styles Hutchins, who were among the first black lawyers to practice in the Deep South, visited Washington, D.C., where they managed to convince Justice Harlan that the state court proceedings in Mr. Johnson's case served to deprive him of his federal constitutional rights, and that the federal courts should intervene in the case. They were later joined by another African-American lawyer, Emmanuel Molyneux Hewitt, who practiced in Washington at the time and who was among a handful of African-American lawyers licensed to practice before the U.S. Supreme Court. Now, many of these lawyers were served as co-counsel with white lawyers, but Mr. Pardon holds the distinction of being the first black lawyer to serve as lead counsel in a case before the U.S. Supreme Court, although sadly he did not have the opportunity to argue the case before the full court. Eventually, the High Court issued a stay of Mr. Johnson's death sentence and ordered the local sheriff to protect him until further proceedings. But before the court could consider the case on the merits, a large mob, armed with guns, stormed the Tennessee jail in which Mr. Johnson was confined. They pulled him out of his cell, took him to a local bridge, placed a noose around his neck, hung him, and shot him several times. Of course, the members of the Supreme Court were understandably upset that the court's order was willfully ignored by the sheriff. Sheriff Joseph Shipp, despite the fact that he was ordered to protect Mr. Johnson, failed to do so. Sheriff Shipp, was firmly opposed to what he considered to be federal interference in state court matters by the U.S. Supreme Court. He himself was eventually charged by the Supreme Court with contempt of court, leading to the only trial proceedings ever conducted by the U.S. Supreme Court. Sheriff Shipp was convicted of contempt, and he was sentenced to a term of 90 days in jail in the Washington, D.C. jail. When he was released, he returned to the city of Chattanooga before a crowd of 10,000 people, a hero's welcome. Unfortunately, Mr. Pardon and Mr. Hutchins, for fear of their lives, never lived in Chattanooga again. Years later, a Tennessee court overturned Mr. Johnson's conviction posthumously after concluding that he did not receive a fair trial on multiple grounds. Ladies and gentlemen, Noah Pardon, Stiles Hutchins, Emmanuel Molyneux Hewitt, and of course, Justice Harlan were all champions for the cause of justice and equality, and they must never be forgotten. In the years following, so many other lawyers, litigants, and judges of all races were inspired by these noble efforts that then resulted in challenges to the racial status quo in many different contexts throughout the United States. For instance, in 1915, lawyers in Oklahoma successfully argued before the U.S. Supreme Court in the case of Gwynn versus United States that grandfather clauses in voting statutes violated the 15th Amendment and served to deprive African Americans of their voting rights. 2 years later, in 1917, in the case of Buchanan versus Worley, lawyers in Kentucky convinced the Supreme Court that housing ordinances enacted by the city of Louisville prohibiting the sale of residential properties to African Americans violated the 14th Amendment. In 1932, the High Court ruled that all people accused of a capital crime, whether in state court or federal court, are entitled to the effective assistance of counsel. In 1948, the court ruled that all criminal trials, whether in state court or federal court, must be open to the public. Closed, non-public proceedings violate defendants' rights. These lawyers and litigants who brought these cases and similar cases are just too numerous to mention by name, but they were all champions for the cause of justice and equality, and they must never be forgotten. Now, in the higher education context, two of the most celebrated and legendary lawyers in our nation's history, Thurgood Marshall and Charles Hamilton Houston of the NAACP Legal Defense Fund, successfully argued to the High Court in 1935 in the case of Murray versus Pearson that the University of Maryland's law school admissions policy of denying admission to African American violated the 14th Amendment's Equal Protection Clause. Later, in 1946, Justice Marshall, joined by his friend Spotswood Robinson, a name I always love pronouncing, himself a fellow Howard University law alum, convinced the High Court that a Virginia law that required the separation of races during interstate bus travel within the state of Virginia violated the Commerce Clause of the Constitution. And of course, we all know of Justice Marshall's epic role in serving as lead counsel in the historic case of Brown versus Board, in which the High Court thankfully finally overturned the abhorrent decision in Plessy and ruled that separate is not equal. Several of these incredible lawyers who labored in the trial courts and in the appeals courts to, in essence, defend the Constitution were eventually themselves called to the federal bench. For instance, much of the original complaint in the Brown versus Board case was drafted by a lawyer by the name of Constance Baker Motley, the daughter of working-class immigrants from the West Indies, who graduated from the Columbia Law School a mere 10 years before the filing of the Brown versus Board case. She was serving at that time as the Associate General Counsel of the NAACP. She had a very illustrious and successful career as a lawyer. In fact, she argued 10 cases before the U.S. Supreme Court, winning 9 of the 10. She would go on in 1964 to become the first African-American woman to serve as a federal judge when President Johnson appointed her to the U.S. District Court for the Southern District of New York. Judge Motley was doubtlessly inspired by a woman named Jane Bolin of New York, who was not a federal judge, but was an inspiring historical figure nonetheless. She was a graduate of Wellesley College and the Yale Law School. And in 1939, at the age of just 31 years old, she became the first African-American female judge in the United States when she was appointed to the Domestic Relations Court in New York. She contributed greatly to the cause of justice by working tirelessly to end segregation in child placement facilities and creating racially integrated treatment centers for delinquent boys. Likewise, we must remember Judge William Henry Hastie, who worked very closely with Justice Marshall and others in the Brown versus Board case. The Harvard Law grad would go on to become the first African-American appointed to the federal bench in 1937. Unfortunately, he did not remain on the federal bench for very long, because a mere 2 years later, he was appointed to serve as the dean of the Howard University Law School. However, he would later return to the federal bench in 1950, after being appointed to the United States Court of Appeals for the Third Circuit by President Truman. Nor can we forget Judge Jacob Trevor, an immigrant from what was then Prussia, now Germany, who immigrated to the United States with his family in 1866 and would attain naturalized U.S. citizenship in 1987. His family settled in Helena, Arkansas. And what sets Judge Trevor apart is not just that he was the first Jewish federal judge in the United States, but that he always exhibited strong concerns about prejudice and discrimination. He issued rulings that acknowledged that certain laws in Arkansas not only served to disenfranchise African Americans, but women as well. He ruled on a number of cases that recognized the fundamental constitutional rights of African Americans, rights to own property, to lease property, and to avail themselves of certain employment opportunities, free of harassment by mobs that were only concerned for their own economic interest. His bold civil rights decisions were pioneering at this time. In 1964, Spotswood Robinson left the deanship at the Howard University Law School and the practice of law to become the first African American to serve in the district court in D.C. He would later be elevated to the D.C. Circuit Court of Appeals, where he eventually became that court's chief judge. And of course, Justice Marshall. Time simply does not permit me to discuss all of the incredible cases he handled in his unbelievable career, or the importance of his presence on our nation's high court. Suffice to say that our judiciary's headquarters building in Washington is named after him for a very good reason. I am one of many persons of all races and all socioeconomic backgrounds who drew real inspiration from Justice Marshall, and we're so grateful for him and his wonderful career. The judges and the lawyers and those who toiled with them, I suggest to you, were all champions for the cause of justice and equality, and they must never be forgotten. Finally, I must take a few minutes to talk about a few judges from here in our neck of the woods. Judges who served on the district courts in the Fifth Circuit, and judges who served on the Fifth Circuit itself. Now, legal historians tell us that after the landmark decision in Brown versus Board, it signaled not only an end to school segregation, but also segregation in a number of other institutions throughout America. However, the court did not necessarily present a blueprint for achieving desegregation, and so it was largely left to the lower courts to fashion a path forward. Now, here in the Deep South, and in the Fifth Circuit in particular, a small group of federal judges, Southern federal judges, fervently believed that it was essential that such guidance come not from judges up north, northern judges, and it wasn't necessarily that they were not sensitive to or ill-informed of the customs and traditions of the South, but they really believed that this path forward would have to be devised by Southern judges in the hopes of achieving greater compliance. These judges were all smart, courageous, and socially prominent in their communities. They came from vastly different backgrounds, but they all had one thing in common, and that was an abiding devotion to the Constitution and the rule of law. For instance, Judge Elbert Tuttle was born in Pasadena, California, and raised in Hawaii. He was a decorated World War II veteran who earned both a Purple Heart and the Bronze Star. He was particularly progressive on issues of race. He practiced law in Atlanta prior to his appointment to the circuit in 1954, and he often said that he could not understand why there was such resistance to blacks and whites just sitting down and socializing with each other. Now, remember, this is when the Fifth Circuit extended beyond just Texas, Louisiana, and Mississippi, but also included Alabama, Georgia, and Florida. Judge Richard Reeves, a native of Alabama, who was a deeply religious man, but he was repeatedly vilified by his neighbors because of his desegregation rulings. In fact, several of his church members at one time called for him to be ousted from their church. Judge John Brown, who was born in Nebraska, attended the University of Michigan Law School. He too served in World War II, and I should have mentioned that Judge Reeves was also a war veteran. But Judge Brown once said, after considering the desperate treatment among the races, said that, black people are people without hope, but the Constitution offers a remedy. And of course, Judge John Minor Wisdom, after whom the Fifth Circuit Court of Appeals headquarters building in New Orleans is named. Now, he was the quintessential New Orleans aristocrat. He belonged to all the highbrow social clubs, even some of which were actually segregated. He was extremely scholarly, and he was elegant in his personal style. He, too, was a World War II veteran, but he was deeply committed to the court's mission of ensuring that all Americans were free to enjoy every facet of American life. He issued rulings that to this very day are followed by courts around the country. His list of prominent law clerks is too numerous to mention here, but suffice to say that two of them include such notables as Judge William Pryor, who now sits on the 11th Circuit Court of Appeals, and U.S. Senator Lamar Alexander of Tennessee, who also served as former governor of that state. These four men, referred to then and now as simply the Four, joined together to issue rulings that integrated schools, lunch counters, bus stations, and other public accommodations throughout the South. And they recognized that African Americans have the right, like all other Americans, to full employment, voting rights, and other fundamental activities of American life. Now, on the district court, Judge Frank Johnson of Montgomery, Alabama comes to mind, also a World War II veteran and a Bronze Star recipient. He issued the orders that protected participants of the Montgomery bus boycott, as well as orders that permitted Congressman John Lewis and others to safely march across the Edmund Pettus Bridge in Selma, Alabama. During his judicial career, a cross was burned on his lawn, and the KKK even bombed his mother's home. Members of the Alabama legislature called for his impeachment, and some even offered a resolution that he not be buried in Alabama soil. Judge J. Skelly Wright, another brave judge from New Orleans, a Coast Guard veteran, who was considered by many to be a traitor to his class for issuing desegregation orders in New Orleans that desegregated not just schools, but several institutions in that city. A cross was burned on his lawn, and the threats to his life were so common that eventually he was under 24-hour Marshal Service protection. In 1960 alone, he struck down 29 laws passed by the Louisiana legislature seeking to promote, restore, and preserve segregation throughout the state of Louisiana. He was eventually elevated to the D.C. Court of Appeals, in part in an effort to remove him from New Orleans and for his own safety. All of these judges and the lawyers who brought the cases before him have made very important contributions to our nation. I suggest that they, too, were champions in the cause of justice and equality, and they must never be forgotten. I cannot close without mentioning two very courageous Baton Rouge natives who did so much for our entire state and our nation. Johnny Jones Sr. Now, Mr. Jones, who is still with us today, he's 101 years old, and he has joined us on occasion for our celebrations. I'm sure that if we could conduct this celebration in person, I'm certain that Mr. Jones would be here today. But Mr. Jones, also a World War II veteran, returned to Baton Rouge to complete his studies at the Southern University, as well as Southern University Law School. In a mere 15 days out of law school, he was recruited to represent black citizens who so boldly participated in the 1953 Baton Rouge bus boycott, which, as we all know, served as a model for the Montgomery boycotts led by Dr. Martin Luther King and, of course, Rosa Parks. His efforts, along with those of other courageous citizens and lawyers, resulted in the repeal of a Baton Rouge City ordinance that mandated the separation of blacks and whites on public buses and, in fact, required African Americans to sit at the back of the bus. Mr. Jones would later go on to work with Thurgood Marshall and A.P. Turo, whose son also has joined us as a speaker for our Black History event, in defending students from Southern University who engaged in a lunch counter sit-in and who were charged with violating certain disturbing the peace laws here in Baton Rouge. They took the case to the U.S. Supreme Court and prevailed. I will tell you, ladies and gentlemen, that Johnny Jones is and has always been a champion for justice and equality, and we all must ensure that he is never forgotten. Finally, I must mention, as I always do, my colleague and very good friend, and a man who served our district for over 21 years as an active federal judge, Judge John V. Parker, who was appointed to the bench in 1979, and who served as the chief judge of this court longer than any other judge. He issued rulings in what was then the longest-running school desegregation case in the United States. He was vilified. He suffered social ostracism. He received death threats frequently, yet it never prevented him from discharging his constitutional duties. He too was a veteran of the U.S. Army. I tell the story about my appointment to the bench and my first day on the job. My chambers were not ready for me. They were being readied and remodeled. And so I called Judge Parker, who was elderly and ill at the time, and I asked if I could use his chambers for a couple of weeks until my chambers were ready. And of course, he said, Brian, absolutely, as long as you want, anything you need, just let me know. I'm here to support you in any way that I can. And Judge, I'm so grateful for that. My first day on the job, the new job, I enter his chambers. I go to his immediate office. I go to hang my jacket in his closet, and I open the door, and what do I see? Was a flyer, kind of tucked away in the corner, that was printed up by the KKK, urging citizens of Baton Rouge to join them in a protest against this wicked John Parker, who is ruining our city with all of his desegregation orders. My friends, I'm so proud of Judge Parker, and I know you are too. And as we all know, Judge Parker was always a champion for justice and equality, and he must never be forgotten. As I close my remarks here today, let me underscore what is so obvious to me and my colleagues on the bench here in the Middle District, and in fact throughout our nation, and that is that none of the bold, brave, historic members of our bench and bar could have considered issuing such historic rulings and opinions that have advanced the constitutional protections for all Americans without the incredibly talented and dedicated staff of law clerks, assistants, court reporters, courtroom deputies, probation officers, clerks of court personnel, who all understand and commit themselves really to the constitutional mission of our branch of government. And so we must acknowledge the brave citizens, the patriotic citizens that bring these cases and who have stepped up to promote these protections and to remind us of the beauty of our nation's Constitution, that it serves to protect and promote all Americans and all American life. And so all of you are also, in your own way, champions in the cause of justice and equality. And I remind you that you too will never be forgotten. Thank you.
Thank you, Judge Jackson, for those meaningful remarks. Ladies and gentlemen, we look forward to gathering together to celebrate Black History Month next year at the Russell B. Long Courthouse in February of 2022. We will close this presentation with a slideshow about one of the judges you have just heard about, Judge Frank Johnson. Enjoy and remain safe.